Hello viewers, we are 2 students at Great Zimbabwe Temple Law School and our facilitator, our lecturer is Mr. Instructor Maphosa. We are going to be presenting on the Competition Law or Competition Act and what surrounds it. Stay tuned for more. Thank you.
Hi everyone, my name is Tadro Chisoro and I'm going to give you a brief discourse about what competition in business is, what competition law is, and why it exists to regulate businesses.
Hi guys, my name is Ellen Chirume and I'm going to be discussing on the successes of the Competition Act.
Guys, my name is Sheltangwaru. I'll be presenting on the disadvantages of the Competition Act.
Guys, how are you? Standing before the podium is Lili Malumisa. So guys, I'm going to be talking about the purposes of the Competition Act.
I'm Advocate Nembiri and I'm here to give up a summary of the points discussed by my learned friends above.
Hello viewers, my name is Samantha Tanesha Makope and I'm a contract law student. So I'll be presenting on the nexus between contract law and competition law.
I'm going to give you a brief definition of what competition law is and why there is need for a competition act or competition law to regulate this competition that exists in business. Competition in business is a rush or contest between two or more business entities or organizations to produce the same type of product for use by the same audience of consumers, or what we call end users. The main question that I'm focusing on is, why is there a need for a competition act or for competition law to regulate the competition that exists within the business? Like I mentioned earlier, that competition in business is a contest between two or more business producers, parties, or entities to provide the same thing to the same people. There is need for this act or for competition law so as to regulate these relations. When we're talking about these relations, we are talking about contracts that exist between the business parties themselves and also contracts that exist between business parties or organizations and the consumers. These contracts or special contractual relationships, what we call in Latin vinculum juris, are regulated by competition law so as to lessen the number of business malpractices or anti-competitive practices that may come as a result. When we are talking about business malpractices, we are talking about those unethical business measures that business organizations or business entities can potentially resort to as a way of curbing competition, gaining greater market share, or gaining profit. The competition law also exists to protect business entities from their dealings with one another. This means that each business organization or entity has to conform to the standards that are laid out in the piece of legislation so as to ensure that they do not encroach onto another business organization's rights or practices, hence affecting their profit at the end. The reasons why people get into business, or the reason why we have marketplaces and business environments, is because the main goal is to gain profit on the part of the business organizations. Then on the part of us as consumers, we need to access products and services. Hence, we should be entitled to the right price for the right good or the right product. This is why there is need for this competition law or competition act to regulate these relationships so that there is enough transparency between businesses and businesses.
Guys, I'll be talking about the purposes of the Competition Act. When we are talking about the purposes of the Competition Act, I will firstly outline the first point, whereby the Competition Act strictly prohibits unfair trade practices. So when we are saying unfair trade practices, we actually mean that these are deceptive ways or fraudulent ways that are used to obtain a business. So these unfair trade practices or unethical conducts that are used to obtain a business, they actually causes harm to consumers, such as misrepresentation, false advertising, selling tactics that are used to obtain a business. Outline and false advertising actually encompasses false sales such as bait and switch. When we are talking about bait and switch, we are actually entailing that it's a practice of advertising one item at a lower price with the intention of actually getting the attention of the consumers to buy the other products in the market. So again, when we are talking about false advertising, we have unfair ads. Unfair ads actually encompasses the categorizing of incorrect pricing, false endorsements, false statements, or exaggerated performances descriptions. So again, I'm going to move on to outline that the Competition Act actually promotes and maintain competition in Zimbabwe. When we are saying that the Competition Act outline and promotes competition in Zimbabwe, we are basically looking at its effects on efficiency and productivity. When we are saying effective and productivity, when we are saying that it affects on efficiency and productivity, we are saying that companies are actually faced with vigorous competition, that they are actually continuously pressured to actually become more, to become more constructive. They're actually finding ways to actually affect productivity and actually seek ways to reduce cost and increase profits in the industry. So when those competitors actually seek ways of actually increasing profits in the industry, they are actually giving pressure to other competitors to also do the same. And when those competitors do not actually do the same or comply to those certain methods, it actually means that they are positioned to sink. So which means the competition industry, it is then actually aggravated for sinking. So I'm actually going again to outline that the promotion of competition in Zimbabwe, it actually results in goods and services being innovated. When we are talking about innovation, we actually mean that innovation, it leads to new products and new production technologies, which actually allows new firms to enter into the market and new products to actually be produced in the market. So without competition, I think there will be little pressure to introduce new products and new production methods. So the reason why I actually first outlined on the prevention of restrictive and unfair trade and practices, it actually means that the consumers, they are the bosses in the market. So actually, I actually think that in the purposes of the Competition Act is to actually outline on the Commission that it has the power to investigate measures and monopoly situations according to Section 46 of the Competition Act. So when we are saying that, I'm actually going to read out that the review and that the monopoly has the power to review a monopoly situation where a conduct of an enterprise group is likely to prevent, restrict, or distort competition or in any other way constitute exploitation of a monopoly situation.
My name is Samantha Panashe-Makobe, and I'm going to be presenting on the nexus between contract and competition law. For one to have a general insight of what all this discussion is all about, one have to first understand what a contract law and what a competition law is all about. Firstly, a contract law is an agreement between two or more parties that is legally binding, freely and voluntarily entered into with consensus. For the sake of the discussion, I'm not really concerned about all the detail. All I'm concerned about is the word agreement. Secondly, what is a Competition Act? Competition Act, these are laws that guides or governs the agreements entered between two or more parties. So this is where the connection between a contract and competition law comes. Competition law is basically concerned about what we call public policy. It avoids scenarios whereby there are unfair business practices that are being practiced by individuals, despite the fact that their agreements were freely and voluntarily entered into. Secondly, I also refer to the case of Delta versus Blackie. The applicant was claiming that the respondent was refraining or stopping him from having other suppliers, which is contrary to Section 43 of the Competition Act. So the court had to consider if the agreement entered by two parties was not in contrary to the Competition Act. The applicant claims that the respondent has infringed his right to economic freedom. The onus shifts to him to prove that indeed the business practice between them is not a fair business practice. I hope this discussion was fruitful for you. Stay tuned for more.
Viewers, so I'm going to be discussing on the successes of the Competition Act. So the first major success of the Competition Act was the establishment of the Competition and Tariff Commission. This commission had the twin mandate to implement Zimbabwe's competition policies and to execute the country's trade policies. The main primary objective of the commission was also to enforce the Competition Act. So over the years, the Competition Act has been successfully implemented through the commission, and the commission has completed its functions. For example, in Section 5 of the Competition Act, it stipulates that the commission is to carry out investigations relating to unfair business practices. So for example, in 2016, the commission undertook an investigation into Delta Beverages for unfair business practices, which it had been alleged to participate in. And after investigations, they determined that there was no unfair business practices that had been carried out. To add on, the Competition Act has also been successfully implemented to combat restrictive practices. For example, in 2020, the Commission undertook an investigation into Warren Park High School, which had been alleged to participate in restrictive practices through the manufacturing and production of school uniforms by their clients, Zilab Consultants. And this investigation made a determination that the school was indeed undertaking unfair, restrictive business practices. And as a result, the commission engaged with the school and they made an order according to Section 31 of the Act to combat the restrictive practices. More so, the Competition Act has also been successfully implemented in mergers and acquisitions of companies. So the Competition Act has also been successfully implemented to ascertain mergers and acquisitions which have been made in the country. So, for example, in 2020, there was a merger between Delta Beverages and Mutare Bottling Company that was determined according to the Act. The mergers and acquisitions are determined in Section 48 of the Competition Act. So the study has been taken and it has proven that since its commencement, the Competition Act's commencement up to 2012, it has facilitated the determination of 137 mergers in the country. So, thank you. This has been the successes of the Competition Act.
Hi viewers, so I'm going to be discussing on the disadvantages of the competition acts. And firstly, I'm going to define the term disadvantage. A disadvantage is a condition which reduces effectiveness. And in this case, we are saying that the Competition Act applies to all economic activities according to research onto my knowledge, I've only covered one disadvantage of the Competition Act, and in this I'm going to cover all the acts in which the Competition Act does not seem to protect. Firstly is the Plant Breeders' Rights Act, Chapter 1836. This is an act which aims at rights granted to the breeder of a new plant, right, and which gives the breeder an exclusive control over the propagating material. And then the second act, which is not protected by the Competition Act, is the Copyright Act, Chapter 2601. This is an act which leads to the acts restricted by copyright law with regards to literacy, dramatic and musical works. Thirdly is the Industrial Designs Act, Chapter 2602. This act protects features of shape, configuration, pattern, or ornamentation, which when applied to an article by any industrial process or means make a finished article aesthetically pleasing. Lastly but not least is the Patents Act, Patents Act Chapter 2603, which aims to consolidate and amend the law relating to patents and to provide for materials incidental or connected with the foregoing. So viewers, we should keep in mind that it must be noted the Competition Act does not apply to the above enactments except to the purposes of enhancing or maintaining forms as constructed in definition 2 of the Competition Act.
Guys, I'm Advocate Shinembe, and I'm here to give up a summary of the points discussed by my learned friends above. So basically, my friend stated that there is an act called the Competitions Act of Zimbabwe. But what's the purpose of this act? Because there can be an act without a purpose. So basically, one of the major purposes of this act is to safeguard the consumers of goods and services in the marketplace from unscrupulous suppliers of goods. Basically, what are we saying here? They are suppliers of goods with the intention of exploiting the consumers by giving them low quality goods and charging them very high prices. So basically, the act encourages competition, because with competition, the suppliers will be forced to up their game in terms of quality, offer lower prices to attract consumers, but not predatory prices. So basically, the act has certain provisions which say that certain monopoly practices or measures are banned. We have what we call collusive measures with tacit intentions. So a collusive measure with tacit intentions happens whereby two or more producers of goods of the same goods and services come together and form one large company with the intention of producing low quality goods and exploiting the consumers by charging them very higher prices. More so, the act states that suppliers, when entering into commercial contracts, they must be fair, and this is in relationship with the contract law. There is a nexus between these two things. Here, on the other hand, with contract law, and on the other hand, with the Commissions Act. The Commissions Act that any commercial contract must be fair, and the contract law, there is a doctrine of fairness. Hence, there is a nexus. But however, we have seen that there are drawbacks to this act. What are those? One of the major drawbacks is the act doesn't set certain regulations as to what happens when there is discovered that there is a tacit measure or a collusive monopoly within the marketplace. It doesn't say the necessary steps to be taken or what to be done. So, in as much as we have these drawbacks, it has brought about some major benefits. This act, it has safeguarded the consumers, and it has also set the commission called the Industry and Trade Competitions Commission of Zimbabwe. Now, the major purpose of this act is to investigate when two or more companies have the intention of forming a merger. And now it investigates the intention of that merger. Do they have the necessary requirements to uphold that merger? So basically, this act has increased innovation within the marketplace because it encourages competition, and due to competition, people will be forced to up their game in terms of the quality of goods and services they provide to the consumers, because the consumers, we as consumers, tend to go to the supplier who is producing the goods of higher quality. So basically, guys, that was our presentation on the Competitions Act. Hope you all understand it, guys. So, quite as simple. So thank you for watching. And before I conclude our thing, I would like to thank our module facilitator, Mr. Maphosa, for giving us such an opportunity to shine in this platform. Thank you. Please, guys, don't forget to like, subscribe, and share this video. Thank you, viewers, for watching. Stay safe. Don't forget to wear your mask and sanitize.